Margaret Osei woke up at 5 in the morning on the day of her court hearing. She did not set an alarm. She simply opened her eyes, stared at the ceiling, and lay still for a few minutes, listening to the birds outside her window. It was the kind of quiet that comes just before everything changes. She made herself a cup of tea. She did not eat. Her stomach was too tight for food. She sat at her kitchen table and opened the brown leather binder she had been building for 4 months, page by page, tab by tab, late into the night after her shifts at the school library. She read through it one final time. Not because she needed to. She had memorized nearly every page. She read it because it calmed her. All that work, sitting right there in her hands. Maggie, as everyone who loved her called her, was 47 years old. She was not tall. She was not loud. She wore her hair pulled back, and she spoke in a way that made people lean in slightly to hear her, not because she mumbled, but because every word was chosen. She had spent years as a paralegal before the small firm she worked for closed its doors. After that, she had found work at the local school library, and she liked it there. She liked the order of books. She liked the way knowledge sat patiently on shelves, waiting for someone to pick it up. The situation that had brought her to a courtroom had nothing to do with books and everything to do with her home. Her landlord, a man named Gerald Fitch, had owned the building where Maggie rented her apartment for 11 years. For 11 years, she had never missed a payment. Not once. She had painted the walls herself when she moved in, fixed the small things that broke without bothering Gerald about them, and kept her space so well that the neighbors sometimes asked her advice on their own apartments. The building was not fancy, but it was hers in the way that a place becomes yours when you put years of your life into it. Then Gerald decided he wanted to sell the building to a developer. The developer wanted the building empty. Gerald needed Maggie gone. He filed an eviction notice claiming she had not paid her rent for 3 months. It was not true. Maggie had every receipt. But that was how it started. When Maggie looked into getting legal help, the cost was far beyond what she could manage on a librarian's salary. She called several legal aid offices, but each one had a waiting list longer than her timeline allowed. So she made a decision that most people in her position never make. She decided to represent herself. She went to the public library, a different one, not hers, and she sat for 12 days reading civil procedure law. She printed every document she could find about eviction cases in her state. She looked up the local court rules. She found something interesting almost immediately. The local court rules had been updated 18 months ago. The version that most people still referenced online was old. Outdated. The current rules were different in one very specific way that would matter more than she could have imagined at the time. She filed her counter-complaint herself. She organized it carefully. She printed 3 copies of every exhibit. She labeled every tab. She mailed 1 copy to the court clerk 2 weeks before the hearing, with a second motion tucked inside, a motion that almost no one who looked at her file would expect to find. The morning of the hearing, she arrived at the courthouse 30 minutes early. She wore a dark blue blazer she had owned for years, pressed and clean. She carried her binder under one arm and a bottle of water in her other hand. She sat down at the respondent's table and placed her things in front of her with the calm of someone who had already decided how this day was going to go. The opposing counsel arrived a few minutes later. His name was Douglas Webb. He was a partner at a firm that operated out of a glass building downtown, and he wore suits that cost more than Maggie's monthly salary. He glanced at her once when he entered, nodded in the way that people nod when they do not really see someone, and then walked over to the court clerk to say something that made the clerk laugh. They seemed to know each other well. The gallery behind the bar was half full. Property cases drew a certain kind of crowd, landlords waiting for their own cases, people with too much time, and 1 or 2 people who simply found courtrooms interesting. They all watched as the door behind the bench opened and the judge walked in. His name was Judge Raymond Coyle. He had been on the civil bench for 19 years. He was a broad-shouldered man with silver hair and the particular kind of confidence that comes from being in charge of a room for nearly 2 decades without ever being seriously challenged. He moved with the ease of someone who had never once walked into a courtroom and wondered how it would go. He had, before that morning, ruled in Gerald Fitch's favor in 2 prior hearings related to this same case. Both rulings had moved the eviction process forward. Maggie had attended both. She had said very little. She had taken notes. Judge Coyle settled into his chair, looked out across the room, and then looked at Maggie with the brief, dismissive glance of a man who had already made up his mind. Douglas Webb rose and delivered his opening motion smoothly. He asked the court to dismiss Maggie's countercomplaint on procedural grounds. He said, with the ease of someone stating the obvious, that her filing did not conform to Local Rule 5.3 regarding citation format. He said it was therefore invalid and should be struck from the record before the hearing went any further. Judge Coyle looked at Maggie. "Ma'am," he said, "do you have legal representation today?" Maggie said that she did not. She was representing herself. The judge's expression did not change, but something in his voice shifted, a small, subtle change that everyone in the room heard but no one could have precisely described. It was the tone of someone who has decided that a conversation will be short. "Then I strongly suggest," he said, "that you speak only when spoken to, and try to follow along as best you can. These proceedings move quickly." Someone in the gallery made a small sound. It was not quite a laugh, but it was close enough. Douglas Webb did not look up from his legal pad, but the corner of his mouth moved. Maggie picked up her pen and wrote something in the margin of her binder. Judge Coyle turned back to the motion on his desk. He said he was inclined to agree with counsel for the plaintiff. He said Maggie's counterfiling appeared to have formatting deficiencies that placed it outside the acceptable standards of the court. He said he was considering striking it entirely. He asked if she had anything to say before he ruled. Maggie stood up. She did not clear her throat. She did not look nervous. She placed both hands lightly on the edge of the table and she looked directly at the bench. "Your Honor," she said, in a voice that was clear and unhurried, "with respect, Local Rule 5.3 was amended 18 months ago. The version that counsel appears to be referencing was superseded at that time. My brief was formatted in accordance with the current rule. I have a printed copy of the amendment and the effective date, if the court would find it helpful." She leaned forward, picked up a tabbed document from her binder, and placed it on the clerk's desk without being invited to do so. The courtroom was quiet. The clerk opened it. Looked at it. Looked at the judge. Judge Coyle picked up the document. He read it. He set it down. He did not say anything for several seconds. Douglas Webb had stopped writing. The judge cleared his throat. He said he would take that under advisement and move on. He did not rule on the motion to strike. He simply set it aside and moved to the next item, which was a review of the prior eviction proceedings. He began to summarize the two previous rulings in Gerald Fitch's favor, speaking with the practiced authority of a man reciting a conclusion he had already reached. He said the prior decisions were sound. He said the case was moving toward resolution. Maggie waited until he had finished. Then she spoke again. "Your Honor, I would like to note for the record that in both prior hearings, rulings were entered before I had been given the opportunity to respond, as required under Section 735 of the State Civil Procedure Code. I did not waive that right at either hearing. I am formally placing an objection to both prior rulings on the grounds of denial of due process." She paused. "I have cited 3 state appellate decisions that speak directly to this issue. Those decisions are in Exhibit D of my binder, copies of which were filed with the court clerk 2 weeks ago and are already part of the record." She named the cases. Not from the binder. From memory. The citation numbers, the courts, the years. The gallery had gone completely still. Douglas Webb was now writing very fast. Judge Coyle leaned back slightly in his chair. His face was steady. He was experienced enough to keep it that way, but something had changed in the room, and everyone could feel it. The ease was gone. The certainty had left the air the way heat leaves a room when a window is opened. He said that the objection was noted. He said the appellate citations would be reviewed. He said they would continue. Maggie said she had one more matter to bring to the court's attention. She turned to a final tab at the back of her binder. "Your Honor, 2 weeks ago I filed a motion for judicial disqualification under Canon 3(e)(1) of the State Code of Judicial Conduct. The basis for that motion is a documented financial relationship between the plaintiff's legal counsel and this court. Specifically, 3 campaign contributions from senior partners of counsel's law firm to Your Honor's re-election campaign, totaling $14,500, all filed as public record within the last election cycle. No one in the gallery made any sound at all. Copies of all 3 contribution records are in Exhibit F of my filing, Maggie said. I filed that motion with the court clerk 2 weeks ago. I also mailed a copy to the State Judicial Oversight Commission on the same day. I am raising it orally now because it has not been acknowledged from the bench. She sat down. She folded her hands on top of her binder. She looked at the judge with the steady, patient expression of someone who has said everything that needed to be said. Judge Coyle called a recess. The recess lasted 40 minutes. When the courtroom reconvened, the person who walked through the door to the bench was not Judge Raymond Coyle. It was a different judge, a woman who introduced herself briefly, explained that Judge Coyle had recused himself citing an abundance of caution, and asked both parties if they were ready to proceed. Douglas Webb, for the first time that morning, looked uncertain. Maggie said she was ready. The weeks that followed moved differently than the years that had come before them. The Judicial Oversight Commission opened a formal review of Judge Coyle's conduct, the first in his 19 years on the bench. The 2 prior rulings in Gerald Fitch's favor were vacated and sent back for rehearing before a different judge. Maggie's countercomplaint, the one that had been about to be struck from the record, was entered in full and given the weight it was always owed. The eviction case was dismissed. Dismissed with prejudice, which in legal terms means it cannot be brought again on the same grounds. Gerald Fitch kept the building. Maggie kept her home. A few weeks after the case closed, a letter arrived at the school library addressed to Maggie. It was from a small legal aid organization that helped people who could not afford attorneys. They had heard about her case, word travels in courthouses, and it had traveled, and they wanted to know if she would be willing to come in occasionally to help other people who were representing themselves prepare their paperwork. She read the letter twice. She folded it and put it in her desk drawer. That evening, she walked home from work the long way, past the park. The trees were just beginning to turn, the edges of the leaves going gold and red the way they do every year without fail, without asking permission, simply because the season had come. She thought about the morning in that courtroom. About the sound in the gallery when the judge had told her to follow along as best she could. About writing it down in her binder. She had written it down not because she was hurt by it, though she was, and not because she was going to use it later, though in a way she had. She had written it down because she had learned long ago that the most important thing in any room where someone has power over you is to stay awake. To pay attention. To let nothing go unrecorded. She had not walked into that courtroom wanting to be a story. She had walked in because it was her home, and she had done the work, and she believed, with the quiet, serious certainty of someone who has read enough to know, that the law, when properly applied, does not care how soft your voice is. She had been right. Her apartment looked the same when she unlocked the door. The books on the shelves. The small table by the window where she drank her morning tea. The walls she had painted herself, years ago, in a color she had chosen because it reminded her of early evening in summer, that particular shade of blue that is not quite day and not quite night. She set her bag down. She put the kettle on. She did not feel like a person who had won something. She felt like a person who had kept something. Which is a different thing entirely, and in some ways a better one. The kettle began to hiss. Outside, the last of the evening light was fading, and somewhere down the street a child was laughing at something invisible, the way children do, with their whole body and no reason at all. Maggie stood at the window and watched the street until the light was gone. Then she turned on the lamp, sat down at her kitchen table, and opened a book. End.